Good afternoon. Can everyone hear me? Yes? Okay. So I am Dawn Irizarry, and that's me. I'm on your screen. There's a picture right there. I'm famous. I am a partner at Carruthers, Sante & Freudenberger. I have been a practicing employment defense attorney for 17 years. I started my practice at a large international law firm, which is a tier 1 law firm in terms of employment defense work. And I've been with Carruthers for about the past 8 years. And this year, I also became a business owner, as I am now an equity partner in this firm. So not only have I been living and breathing this stuff for my clients for the past 17 years, it now affects me personally as a business owner. Okay, so enough about me. I want to know a little bit about some of you. Now, how many of you are business owners? Okay? How many of you serve in an HR capacity and/or a management capacity? Okay. How many of you are here because you want to find out how you can lawfully smoke weed in the workplace? Okay. Anyway, I digress. So my law firm, Carruthers, Sante & Freudenberger, we are a California-based law firm. We have 5 offices throughout the state of California, 2 in Northern California, 1 in Los Angeles, which is where I practice, Orange County, and San Diego. Our firm practices exclusively in the employment arena. We also handle immigration issues, so if you have an employee from overseas who you would like to bring over to the United States to have them work for your company, sometimes that's in the medical field, the scientific field, we can help you with those the visa application. We also handle trade secret work. Okay, this is a fascinating subject because federal law and state law don't really align. And so for employers and managers and people who are overseeing employees, they don't know how to handle a situation when an employee either tests positive for marijuana or comes to them and says, hey, I've got some condition, medical condition, and my physician has recommended that I use marijuana to treat that condition. So what's the federal law? Federal law, marijuana is not legal under federal law. It is a Schedule I substance under federal law, and that you can be prosecuted in the state of California under federal law if you use, possess, or grow marijuana. But that's not the end of the analysis, because most states, and I'm going to just correct some of that, most states have passed laws allowing for medical use of marijuana. And some states have passed laws that allow for recreational use. So how many of you know where California lies in that little dichotomy? What do you think? Both, right? Okay. So initially, these laws were designed for medical use. A lot of states, California not being the first among them, passed laws to allow for the medical use of marijuana, and the purpose, or the intended purpose, was to insulate physicians who recommended or prescribed marijuana for the use, for the treatment of some medical condition, and to insulate those individuals who in fact did use or consume marijuana for that purpose. Since then, 33 states have laws that legalize the use of marijuana. That number is somewhat misleading because really, today, all but 4 states allows some form of medical marijuana usage. And so we say 33 states because the remaining states that make up the difference between the 4 that remain, they have small amounts that you could use for medical purposes, but it's so limited that it's not this broad statute that allows for you to use it under the same circumstances that California and some other states allow. Of those 33 states, many also allow for recreational usage. So 11 states, including DC, allow for recreational usage. I've listed the states there, in case you're traveling and you just want to know. Just saying. No judgments, no judgments. Okay, so what's the law in California? California allows for the use of medical marijuana if it's recommended by a physician for a patient who is seriously ill with certain conditions. And I've listed some of those conditions here. There are others. There are also, we allow for recreational use since 2016. So consumers, such as all of you, can purchase small quantities. You can possess it, you can use it, and you can even grow it in small quantities, marijuana, in the state of California. And if you are a business, you can, if you have the proper licensure, you can grow it, test it, and sell it within the state of California. So what does that mean in the employment context? Because that's really why all of you are here. You're not here, well, some of you are not here to find out how you can, or if you can smoke marijuana in the workplace. You're really here to find out, what does it mean in terms of governing your workforce? Now, interestingly enough, some states prohibit an employer from making any employment decision based on marijuana usage. Arizona being one of them. In fact, in Arizona, some employers have created designated smoking areas for pot. Can you believe that? So before you run out and try to figure out who those employers are, let's talk about what it's like in California. So I've listed the other states, though, just so you know, Arizona, Arkansas, those are the states that prohibit an employer from discriminating against an applicant or an employee based on medical marijuana usage. However, some states explicitly allow for the termination of an employee based on marijuana use at work and or including the use of medical marijuana. Does anyone in this room know where California falls in that little analysis? Somewhere in the middle? Okay, so as business owners, as managers, I think it's fair to say there's a lot of discussion about, in California, it's very heavily skewed towards protecting employees. As an employment defense attorney who lives and breathes this stuff all the time, I can say with certainty that that is in fact the case. I've practiced in the state of New York. California is much more geared towards protecting employees than almost any state in the nation. And that's good or bad. I mean, depending on your political affiliation, you may think that's great, you may think that's terrible. As a business owner, there's a lot of issues that arise because of that. One, it's more expensive to do business in California. Two, there's a threat of litigation all the time. And three, because California is sort of on the forefront in many issues, it's really important that you stay up to date in terms of what is the current status of the law, because what I'm telling you today could change tomorrow. So I'm just making you aware of that. California is not the most liberal state in the nation on the issue of marijuana in the workplace. So some of you managers, employers, business owners can breathe a sigh of relief for a second, because then I'm going to get into why you still need to be on your toes about this issue. So there was a case handed down in 2008 by the California Supreme Court. It's Ross versus Ragenwire. It has a lengthier name than that, but for purposes of this discussion, I'm going to refer to it as Ross. In Ross, the applicant, he He was a former pilot in the Air Force. He sustained serious injuries while he was in the Air Force, back injuries. And his physician prescribed medical marijuana to help alleviate some of the pain that he experienced. Drug testing in California is allowed post-offer. He was given a drug test post-offer, and it came back with traces of marijuana in his testing. So his employer spoke to him and said, your test came back, and we see that you've been using marijuana, and we can't hire you because we have a drug-free workplace. And he responded by saying, hey, my doctor prescribed this or recommended this, and I'm using it for that purpose, and I expect you to accommodate me. This went to the county courthouse. They dismissed his case. They said you cannot state a claim because marijuana, while it may be lawful for this purpose in California, it is still unlawful under federal law. Went up to the Court of Appeal. The Court of Appeal said, we agree. It's unlawful. An employer can have a drug-free workplace, and you have no case. You can't even state a claim. You can't even get past the pleading stage. Now, that's a big win for employers because I'm expensive. And so the pleading stage is basically they file a complaint, and then your employer or your attorney would answer. That may cost you, I don't know, $5,000, maybe a little bit less, whatever. But if it gets past the pleading stage, you go through discovery. And I can tell you a single plaintiff case to get through discovery to a point where you can get it dismissed, if you can get it dismissed, can cost you hundreds of thousands of dollars. So if you're a small business owner, it could literally put you out of business. So that's an important decision, and one you don't see very often in California. Went all the way up to the Supreme Court, and the Supreme Court had this to say. Said a couple things. One, there is nothing in the legislature that protects employees who use marijuana. While it may be lawful for medical purposes, there is something called FEHA in the anti-discrimination statutes, and there is nothing in there that protects an employee for using marijuana in the workplace or outside of the workplace for medical reasons. The court said you may make an employment decision based on medical marijuana usage. That is a huge decision and a huge win for employers because many employers want a drug-free workplace. And you can see why, right? Depending on the industry. If you're in, many of my clients, I represent Cedars, I represent DaVita, they're healthcare organizations. Many of you in this room could see why you wouldn't want your surgeon, lighting up before they perform surgery, right? You wouldn't want your pilot, if you're taking a flight to Arizona to go work for those people who allow you to smoke on site, you don't necessarily want your pilot lighting up before he takes off, right? I mean, I'm just saying. So, what does that mean? So what's the status of the law now? Well, last year, there's a big push, Assembly Bill 2069 in California, and that was an attempt to enact anti-discrimination provisions in California based on medical marijuana usage. So that effort was basically an effort to overturn Ross, because there was a coalition of people saying, look, we like our weed in California, and if we need to smoke it because we are sick and our physician prescribes it, my employer should have to accommodate my weed usage, and I shouldn't have to worry about being fired for that. Interestingly enough, it stalled and died a slow death. So here's the question that I want you all to be thinking about as you're addressing these issues, and I'm going to get into how you address them. I'm just giving you the background. You need to think about, where are we now? And I can tell you, I'm going to go through some slides, where we are now is more and more states are moving towards enacting anti-discrimination legislation that protects employees who use marijuana for medical purposes. This is California. We were not the first state to allow for recreational use of marijuana. We were not the first state to enact legislation that allowed for medical use of marijuana. So it's not surprising that we wouldn't be the first state to enact anti-discrimination legislation in the workplace. But I suspect we will. I suspect that will be coming. And so I think all of you should be thinking about that and really trying to stay up to date in terms of where these laws are headed and where they're going. And I'll explain to you one way that you can do that towards the end. So what about federal contractors? Now, I'm sure most of you may have heard that under federal law, there's a Federal Drug-Free Workplace Act. And that act basically says if the employer does business directly with the federal government, medical marijuana cannot be tolerated in the workplace at all. At all. So anyone who has a federal contract to do work with the federal government. And that seems to make sense, right? Because marijuana usage is unlawful under federal law. So in 2009, just in case anyone was confused about the Department of Transportation's position on this issue, they issued guidelines that prohibit the use of medical marijuana for transportation workers in safety-sensitive jobs, including pilots, those people who are like truckers who drive across straight lines, anything that involves interstate commerce. So when you think of federal, you're thinking interstate, people that are crossing state lines. And if you think about it, it makes sense. Whatever your views may be on medical marijuana usage or even recreational usage, seems to make sense, like we talked about. While you may want to go to some place on your off time to smoke marijuana, you wouldn't necessarily want a pilot flying you there who has been, using marijuana within the last hour or so. So that all makes sense. Now these guidelines, again, the political climate, it shifts one way one day and the next goes another way the next day. Just in case there's any confusion, those guidelines were confirmed as recently as April 29th of this year. So the DOT, the Department of Transportation, maintains the same position that it articulated in 2009. But in the law is a funny thing, and this is why many people hate lawyers. Because you ask us what you think is the most straightforward question, we're like, it depends. And nobody wants to hear us depends. They're like, how much money do you get paid an hour to tell me it depends? Like, I could talk to some fool on the street and they tell me it depends. And the reality is, it really does depend. So there has been case law involving federal contractors on this issue. And the interesting thing, the Ninth Circuit, and some of you have probably heard the Ninth Circuit is considered one of the more liberal circuits in the nation in terms of their opinions. Interestingly enough, in this case, it involved an employee who worked for an employer who had a federal contract. So the Drug-Free Workplace Act was implicated. And there, the employee was involved in an accident in a company-issued vehicle and tested positive for marijuana. The employee was terminated, and the employee argued that under Montana's Medical Marijuana Act, their termination was unlawful. There, the court held the employer was within its right to terminate this employee because the state law did not have anti-discrimination legislation built into its Medical Marijuana Act. Meaning, like California, there's nothing built into the law that says while you can use it for medical reasons, there's nothing that says you can use it for medical reasons while at work or be under the influence while at work. That's important because also last year, a district court in Connecticut which I believe is the Second Circuit, ruled in favor of an employee who basically alleged the same thing. Employee worked for a federal contractor. That employee tested positive for marijuana usage while at work. And that employee, or no, it was a job offer that was rescinded. Sorry, slightly different facts. But in that case, the court said that the employer did violate the employee's rights in terminating him because the state law that was implicated did provide for the anti-discrimination provisions that protected that employee based on medical marijuana usage. So even at the federal level, what it's important to remember is they are deferring to states, okay? There's such a thing, and I don't want to get too complicated. Under federal law, there's a thing called federal preemption. And again, I don't want to get too complicated, but federal preemption means that from a federal standpoint, we occupy the space. We get to decide what happens. States can't interfere because it implicates interstate commerce, so we occupy the field. So in order to determine whether it's implicated, you need to look at whether there's a conflict between the state and federal law. Some of you looking at this may say, well, there's a clear conflict. I mean, one says you can use it, one says you can't. The difference is what this court in Connecticut, which I think is really important, held is that there's no conflict because if we go back, the Drug-Free Workplace Act states that you cannot tolerate medical marijuana usage in the workplace. This district court case in Connecticut, it was a pre-employment drug screening, and you cannot determine when someone used marijuana when it shows up in their bloodstream. You can't say, well, it's not like alcohol where you can say there's some window of time where it disappears. It's a 30-day thing. So if you use marijuana within 30 days, it's going to be maintained in your bloodstream. So you can't say that they were using it while at work. So it's really important. So all of this said, you don't need to know about federal preemption. You can throw it around if you want to like impress your friends. But what I would say is it's really important to stay up to date in terms of what's happening in California, because if the current state of the law changes, the advice to you would change for obvious reasons. Okay, so what does that mean for you, for all of you, when an employee comes to you? So it's important to remember disability, FEHA, there's the ADA and FEHA, and they provide that you cannot discriminate someone with a disabling condition that impairs a life activity. Then you've got the failure to engage. That can be a claim, a failure to engage in the interactive process. How many of you have heard of that? Okay, let me tell you what that means in just layman's terms. When someone comes to you and they say, I've got this disabling condition, or I've got this condition, they don't have to say it's a disability, and my doctor said, I can't lift more than 5 pounds, or I need wrist guards, or I need a chair that will give support to my back. You need to engage in what they call the interactive process to see if you can reasonably accommodate that employee. Okay, 5 or more, if you have 5 or more employees, you need to know that. So there's anti-discrimination statutes, and in this context, medical marijuana usage, it mostly comes up in disability. They'll say, I've got a disabling condition, I have cancer, I need to use, my doctor has prescribed marijuana. So the tricky part is, I just told you, you don't have to accommodate medical marijuana usage in the workplace, right? You're like, Dawn, why is this an issue, right? You don't have to let someone light up in the break room. You don't, just so you know. But what you need to do is you need to accommodate the underlying condition. So you need to engage in the interactive process. So if they say, I have cancer, I have to smoke marijuana every 8 hours. And that's what I need to do. You don't have to allow them to smoke marijuana on your premises. You can, Ross actually says you can if you want to, but you're not required to do so. But you do need to engage in the process to see if you can reasonably accommodate that employee based on the underlying cancer condition. And so they say to you, well, I need to take this every 8 hours. Maybe they can work from home. Don't know if you want to do that. Maybe they can work 4-hour shifts so that there's some time in between. Maybe there's some other treatment that they can follow without asking them to tell you their diagnosis, because you can't do that either. What you have to do is engage in the process to find out if there's some other form of an accommodation that you can provide to him or her. So it's no different than if an employee says, you know, I have a carpal tunnel syndrome, and they have to type. That's an essential function of their job, they have to type. Well, maybe you can get one of those devices where you talk into it and it types it out for you. That many people, if you're a big organization, that would be a reasonable accommodation. It's not too expensive, and maybe it's just as effective. So you have to be creative and engage in that process. So while it's true, you don't have to let them light up on the work site, that doesn't mean you can just say, showed up in your bloodstream, we've got the test, you're fired, peace out, I'm done. No, you gotta have a dialogue with them, okay? That's really important. And you have to reasonably accommodate the underlying condition. Now, when employers start saying reasonably accommodate, it's kind of subjective. This is one of those areas where I find employers, in many cases, get it wrong, because it's subjective. So what's reasonable to you might not be reasonable to the next person. As outside counsel, when I'm involved in these cases, what I'm looking at is the size of the organization. So if Cedars comes to me and says, you know, we think it's unreasonable that this person wants this device where you talk into it and it types for you, and I'm like, well, what does that even cost? And they say, I don't know, $250. I'm like, you're going to lose that case. If you fire them for that, you're going to lose that case. Or can you put them someplace else? That's not a case that you want to litigate, because you're going to spend a whole bunch of money on me, and you still might lose. But if you're a small mom and pop shop, and in order to reasonably accommodate, you have to really change the conditions of the work environment to a dramatic degree, then I would say, well, that's not reasonable. You don't have to accept what they're asking you to do as a form of accommodation, but you need to explore other forms of accommodation. So it's about dialogue, okay? Dialogue is important. So in a nutshell, when someone comes to you, if they either test positive or they come to you and say, you know, I've got this condition and my doctor has prescribed, you can say, well, okay, you know, if you're a hospital and you have a drug-free workplace, then it's important to engage in the dialogue. You have to, by law, do that. And you have to try to reasonably accommodate the underlying condition. Does that make sense to people? I know it's like a fine distinction, but it is really where these cases turn. And I can tell you, based on my own experience, there are a few areas of the law where employers, even though they may be well-intentioned, oftentimes get it wrong. I would say in California, wage and hour is one such area because it's kind of complicated. It's changing all the time. The other area is leave laws, disability, accommodation. Like, more often than not, employers somehow trip down that journey. So I think it's really important to kind of understand what you need to do and what you can't do. This just kind of reiterates employers' obligation. They do not have, again, the obligation to accommodate by allowing marijuana usage in the workplace, but they must engage in that interactive process in an effort to accommodate the underlying condition. Also, employers with 25 or more employees have an obligation to reasonably accommodate employees who seek treatment for alcohol and drug addictions. So if someone is addicted to marijuana and they want to seek treatment, if you have 25 or more employees and they need time to do that, and it's not going to be an undue burden or hardship for your company to allow them the time off to do that, you need to do it, okay? And again, reasonably undue burden, get a gut check, because it is subjective. You know, anytime an employer has to write a check, they may think that's an undue burden or not reasonable. But the law will see it a little bit differently. So definitely get a gut check on that. To test or not to test? Okay, so drug testing anywhere implicates all sorts of rights, including the right to privacy. And so a lot of employers test, they just have these mandatory testing policies, but I really think it's important, especially in California, but really in any jurisdiction, to really look at your business and determine, is that necessary? Okay, you know, again, healthcare setting might be different from a bar owner, you know? It just, the practical realities are, it's different. And so think about, you know, do you really need to perform a drug test? Because employees generally don't like it. They feel that it's an invasion of their privacy. The California Constitution says it is an invasion of their privacy. But nevertheless, you can do it. You just have to do it under the right circumstances. So if you're going to perform drug tests in the state of California in the employment context, it must be post-offer. Okay? After you give them an offer, you can then invade their privacy by having them submit to a drug test. If it comes back positive, you have to engage in the same process that I just described. Okay? If it comes back positive for traces of marijuana, you want to have a dialogue with them. The Ross situation, the court noted very clearly that the case may have turned out differently if the employee had identified some other form of accommodation that they were seeking. In that case, they were saying, you need to accommodate my marijuana usage. And the court said, no, they do not. So if, in that case, they said, or alter my work hours or something like that, the decision may have turned out the other way. So if, however, drug testing in the employment context. So if you have mandatory drug testing, it must be post-offer, and then again, if it comes back positive, engage in that process. Random drug testing. Generally speaking, that's a no-no. You don't get to just randomly decide that, you know, once you have an employee on staff that you want to just have them subject to random testing. You have to have a reasonable suspicion that they are under the influence and poses some threat to either him or herself or to the public. So those are the circumstances under which you can perform a random drug test. Okay, that's really important. Random drug testing used to be pretty prevalent in the state of California. Now, not so much. Now you really need to analyze the situation from the standpoint of you need to come at it from this is a clear violation of their right to privacy. And if I'm going to do it, there has to be some compelling need. And the compelling need is really they could hurt themselves or someone else. Yes?
That change with safety-sensitive personnel because we have drug programs that have randoms.
Well, safety-sensitive personnel, it's a public policy issue. So if there's someone who's, I don't know, operating machinery, heavy machinery that, you know, they could like chop their hand off. Same thing. Safety sensitive, yes, same thing. So same analysis of, you know, you don't want your pilot taking you to Arizona so you could smoke your weed to be under the influence, right? Because there's a lot of lives at stake if something happens.
So does most of this not apply to safety sensitive?
Yeah, it's like a common sense approach in that sense, because while there's definitely a strong public policy that protects an individual's right to privacy, there's an even greater public policy that protects the public at large. And so that's the thing about a lot of these laws. There's always like a balancing act. And so what I was telling someone earlier is that a lot of times these laws are in place because a lot of people don't do the analysis correctly. Like anyone, like what you just said, anyone would be like, well, yeah, I don't want somebody high when they're, you know, they're flying a plane or whatever. But then some people extend it to like, you know, okay, I own a bar. I don't know, if somebody's mixing your drinks and, you know, they smoked the night before, does that really impair their ability to do their job, to mix drinks? You might have a better drink, I don't really know. So there is like, it's commonsensical, but what happens is a lot of time people have personal views on the issue, and so they mix their personal views and lose perspective in terms of what objectively most people would not be concerned about. So, okay, employers should clearly state its position on medical marijuana. We're talking about policies here, and what you need to do, and I included this, and there's a few materials that you have. One is my presentation materials. Another one is an article that I did not write, but my picture's on it just because I'm here today. But another partner at my firm authored an article for Money Magazine, and I included it. And I consider it a cheat sheet for purposes of this discussion. And it really goes through and gives you some really concise advice in terms of how to word your policies, what they should say. You don't want to have a zero tolerance policy in writing. What you can say is that no employee can be under the influence while at work. But to say you have a zero tolerance policy in all cases can get you sued, because you do have the obligation to accommodate the underlying condition. Does everyone understand that?
Doesn't that apply to employees more than 25?
5. 25 is for the drug rehab, alcohol and drug rehab, 5 for FEHA. Okay. We kind of went this post-offer pre-employment testing. This just really talks about when you can do it, who you should use if you decide to do it. Anita certified lab. That avoids hiccups. I call them hiccups. That means litigation. That's a nice way to say litigation, potential issues, legal issues. And really, Anita certified lab they have a certification. They are in compliance with the laws, that their tests are performed in a way that garners accurate results. So you want to, if you're going to do it, then you want to make sure that you are doing it in the most reasonable way, in a way in which is going to be least likely to get you sued. No good deed goes unpunished, workarounds, last chance agreements, all of these things. If you do have a no tolerance policy where you say you cannot be under the influence while in the workplace, someone tests positive, there's nothing that says that they're using it for medical reasons. You are an employer who is in a safety-sensitive position. Some employers are, no good deed goes unturned. They say, okay, the employee comes to them and says, I need this job, but I really, really need this job. And I'm not going to do it again. I was just getting high with my friends this weekend. Someone told me to try it. I tried it, whatever. If you can tick off all those boxes and you want to do a last chance agreement, which is an agreement saying I'll never do it again, you're just waiting for a lawsuit, in my opinion. Because there's another claim that other employees can bring. Negligent hiring, retention. There's a paper trail. If you've got a positive test for marijuana usage and you're in one of those safety-sensitive areas and you gave someone a second shot, and God forbid they either operated machinery that resulted in someone losing a finger or crashing a plane or driving a bus into a wall, forget it. You've just created a punitive damages case like no other. Whether you're big or small, it's going to hurt. It's going to cost a lot of money, and any good attorney would tell you to settle that probably for somewhere in the 7+ figure range. That's all I have. Questions?
Okay, Don, we're going to have some hands up. Surprising people have questions, but hold on just one second. Steve Ulios from Jersey Mike Sub. Steve?
My question, you had said in one of your earlier slides that an employer may make a decision to allow for medical marijuana in the workplace. If you allow it for one employee, does that then set a precedent that you then have to allow it for another, even though conditions might be different?
Yes, you are setting a precedent, and unfortunately, it goes into the no good deed goes unpunished, because if you allow it for some...
There you go. So right here, Dawn, just talk really loud into the top of it.
So if you allow an employee to use marijuana in their workplace or even while they're on break, say it's a white male, 35 years old, and then you think, I don't know if we want to do that anymore. And then a female over the age of 40, she comes to you 2 months later and she says, well, I have cancer too, and my doctor recommended it, and so I want you to accommodate me. You've set a precedent. So why are you telling this white male who's under the age of 40 that he can do it, and then you're going to turn around and tell this female over the age of 40 she can't? And so she's going to say, you're not treating me the same, we're similarly situated, but you're treating us differently. And the only thing I can point to is that he's a guy, younger than 40. I'm a lady, older than 40. I'm in 2 protected categories, and I'm going to sue you. And what are you going to explain? Well, we just changed our mind? That would be a case where I would say, I don't know if she's going to get a huge amount of damages, but I would pay this to go away because you're going to pay me a lot more.
What are your thoughts about doing drug testing after a workplace accident?
If you have reason to believe that the person was under the influence, alcohol in their breath, slurring their words, seemed spacey and out of it, yes, I would highly recommend it.
But only if we have a reasonable suspicion.
You have to have a reasonable suspicion.
Okay, so it can't just be anybody who has a workplace injury.
Not really, because, sadly, in California, you have to look at the totality of the circumstances. An accident, for proper investigative purposes, almost in all cases, you can somehow justify it. They seemed a bit off. They seemed highly agitated. They were, it could be anxiety, frankly, but the circumstances are usually such that they would lend itself to a justification, especially if it's a school bus. Nobody's going to really argue that it made sense to do that, except the person who you might fire. But the flip side is if you don't, especially in a safety-sensitive area, you're going to get sued by a whole bunch of other people and the liability is going to be significant because if they're in a position where someone else's life is at stake, that's a punitive damages case. And so, again, if they're at work and they're a bartender and they drop a glass and they cut the toe, someone, injures themselves, no, I wouldn't. If they flip bottles usually and it's whatever, if they missed it and they messed up. But if they're driving a car or a bus or in some sort of large transport or if they're involved in, patient care or something like that and they're off, how are they off? Well, they weren't lucid, they were slurring their words, they just seemed spaced out. You want to do it because the public policy is so great and the potential harm is so significant that it provides a compelling need to perform the random drug test.
Dawn, we have a question here in the middle. Laura Kirchhoff from Circle of Hope.
Hi. It might be a two-part question based on how you answer the first. How does CBD oil play into this as far as under federal law? Is that allowable under federal law versus state?
Under federal, CBD oil, I don't know, to be honest with you, because under federal law, any use, possession, and I don't know the trace amounts, but I don't think there is a minimum amount, but it's really use, possession, and sale. So based on that, and I apologize, but I don't really know if there's some absolute low amount, like any traces. I believe that it's any amount is unlawful, but I'm not 100%. I don't want to say that it's absolute, because we don't deal with that very often. It's usually someone who's smoking is the normal context, but I'm happy to get back to you on that. But if I were to just give an educated guess, I would say any amount, including CBD oil.
And because my question is actually, it doesn't have to do with a employee. It has to do with a sponsor. I am a nonprofit organization, and we put on events where we ask for sponsorships. I have recently been approached by a CBD oil company wanting to sponsor an event, and it pained me to turn that money away, but I did, because we are a nonprofit with a 501c3, which is a federal document. It's a federal a statement that we have as a nonprofit organization, and I was not sure if that not being legal under federal law would put our nonprofit status at risk.
That is beyond my expertise because it's not an employment relationship. It's really a business decision for you. So I'm not going to advise you. I can't advise you because I don't know the answer to your question. But I would think that barring any issues under the provisions that govern nonprofit organizations, that from a legal standpoint, you should be okay. But I don't know what those provisions are that govern nonprofits. That's not my area of expertise. I have no knowledge of that area. But I wouldn't think it would be an issue, but I don't know. So, I mean, I'm sorry. I wish I could give you a better answer, but it's really not my area of expertise.
Don, we have another question right up front to the right.
Actually, more of a comment. I do employ pilots, mechanics that are safety sensitive. CBD is not an illegal compound. It does not have THC in it. I actually have a couple pilots that use it. They are on a random drug and alcohol program, as all of our safety sensitive guys are. There is a study that came out from the FAA yesterday talking about synthetic THC that is in some of the CBD compounds illegally, but any reputable CBD company should not have THC in it, and it's been through our drug and alcohol program. It's 49 CFR 40 is what it got approved under, and they can use CBD.
Well, there you have it.
Okay.
I also have a comment in that as far as the defense costs go, most insurance liability companies won't really cover your defense in this. Am I correct in assuming that? If you did get sued.
No, that's not true. EPLI. There's EPLI insurance, which is employment specific, and then there's some like umbrella policies that will cover it. I'll give you a quick overview of how that works, but basically EPLI usually has a retention or deductible. They usually pay set rates. Their set rates are usually far lower than, like my firm, Cedars, other companies, they may have EPLI, but the rates are so low and the retention is so high that they're, for all intents and purposes, self-insured. But the way it typically works is they have a panel of law firms that they use that will accept those rates. You then have to accept one of those firms for coverage purposes. If you decide to go outside and use a different firm, then your company would be on the hook to pay the difference. Because like our firm, that's what we say. We're not going to accept, $200 an hour, our rates or whatever, and you pay the difference. And as long as your carrier is okay with that. And some employers have very good coverage. Some only have a $10,000 deductible. Some have a $25,000 deductible. Some have a $1 million deductible. It really just depends on what you're willing to pay for a premium. But what they won't cover is wage and hour, because then everybody would just stop paying their employees in accordance with the law, knowing that the carrier is going to pick up the cost. So they do handle anti-discrimination claims, retaliation, wrongful term.
And a wage and hour could turn into a PACA claim that could get pretty scary.
Wage and hour is scary in general. PAGA is a whole different breed. But you are right, fees, it's just, they increase exponentially when you're talking about wage and hour, especially in a class action lawsuit.
Okay, do we have one last question? Because Dawn has been up on stage for a long time. Sorry, Dawn, didn't mean to scare you. Do we have any other questions? One last question in the room. Everybody's well educated on marijuana in the workplace. Dawn, let's give her a nice round of applause, ladies and gentlemen.